quite an international group of scholars here presenting papers on a diverse range of topics. So I'll start to my right here. Marek Martinisian will talk about what happens when foreign states become involved in anti-competitive conduct causing harm abroad. Then we have, I'll skip over to Nia Dunn. She'll be examining in her talk on her paper the functioning of EU law as a vehicle for rate setting within national markets, considering both competition law and legislative approaches with a focus on digital sectors. And then finally, Avery Bose, right, skip one more down. He'll be, with his paper, discussing an examination of the Competition Commission of India's antitrust enforcement efforts with comments on the demonstrated level of commitment or lack thereof, really, to a view of the centrality of markets. So we're going to be breaking this panel down into 3 discussions, and so I'll, instead of sort of going through the litany of these very impressive CVs, I will introduce each presenter in academic discussion in pairs. But we do have the practitioner discussing as a constant. So let me introduce Liesl Dunlop. Liesl, wave at the end of the table there. Liesl is a partner at Manatt, Phelps & Phillips. She advises U.S. and multinational companies in an array of industries, media, technology, healthcare sectors, and she does that in connection with a broad range of antitrust counseling issues, antitrust litigation, and transactional matters. She has significant international experience. You can probably tell she has a bit of an accent. She has experience both in Australia and throughout Europe, actually, and has appeared in front of a number of competition authorities. She has her LLM from Cornell University Law School and has a Bachelor of Laws as well as a Bachelor's of Science from University of Sydney. So welcome, Liesl. So we have a lot to cover, so I will move to our first presenter, as well as introducing the first academic discussant. To my right, Professor Marek Martinisian will discuss his paper entitled Foreign States Entanglement and Competitive Conduct. He is a lecturer in law at Queen's University Belfast School of Law. His research focuses on comparative and transnational aspects of antitrust laws, and he has a number of papers, has been very active. Marek has been also nominated by the Polish Competition Authority to serve as an NGO to the International Competition Network. He was awarded his PhD in law by the University College Dublin, Ireland, and an LLM by the Saarlands University's European Institute in Germany. And then I will, commenting on the paper as our academic discussant, is Professor Edward Kavanaugh of St. John's University of Law. He also has his LLM and his JSD from Columbia University and a JD from Cornell. Professor Kavanaugh has lectured and published widely in the areas of antitrust, federal procedure, practice, and complex litigation. Thank you.
Thank you, Liz. Many thanks to the organizers and sponsors for making this terrific event possible. My paper constitutes a mapping exercise contextualizing foreign states' involvement in anti-competitive conduct affecting other jurisdictions. From a competition perspective, the question of foreign states' responsibility for competitive harm elsewhere is somewhat under-researched, and I think this paper makes contribution that's somewhat filling that gap. Interestingly, states continue to facilitate or even encourage outbound anti-competitive conduct, and I think we don't speak about it often enough. In the paper, I examined 3 questions. The first and principal question, how a foreign state may become entangled, that is involved or implicated in an antitrust case in a foreign forum. And I will focus on this question during this short presentation. In the paper, also discuss how we should go about such entanglement and what are the relevant broader considerations. So my first question, how a state may be entangled in an antitrust case? First, I think it needs to be pointed out that competitive harm is central to any transnational antitrust case. And there are various acts and policies of a state which may lead to its entanglement in an antitrust case in a foreign forum. And these acts and policies can be divided into those leading to a harm, and acts and policies take any reaction to foreign enforcement. In that latter category, define, for example, introduction of blocking legislation, submission of amicus briefs, or some extra legal reactions, for example, exerting a pressure on another jurisdiction, or for example, engaging in a trade war. And I discussed this briefly in the third part of my paper. In the next couple of minutes, I would like to focus on those acts and policies leading to the harm, and I think this can be further subdivided into unbound-oriented activities and inbound-oriented activities, or in a nutshell, those acts and policies related to selling and buying. So let's look at the unbound-oriented activities. First of all, and that's the most straightforward case, a state may be directly or indirectly involved in commercial activities. It may itself participate in anti-competitive conduct affecting foreign forum. In such a case, there is no logical reason why a foreign state should benefit from any sort of privileged treatment, special treatment as compared to other market participants. And recent comparative research, for example, of Professor Fox, present here, shows that a growing number of jurisdictions subject their own state-owned enterprises to domestic competition regime, and I think we should do the same in transnational context. Moreover, most jurisdictions nowadays follow the doctrine of restrictive state immunity, which limits state immunity only to sovereign acts of state, and doesn't extend them to other sorts of conduct. And I provide some examples in the paper, which I want to mention now. Now, the next activity potentially implicating a foreign state is that of facilitation. And I think facilitation is a fascinating category of acts. We have all sorts of activities and policies in it. For example, export cartels. Most competition regimes those competition laws are usually applicable only to conduct affecting domestic market. So long as you have a cartel which affects only foreign market, that will be perfectly fine under virtual or competition laws internationally. Export cartel is a specific case, but we can have a larger category. A state may more broadly limit the reach of own competition laws so as to protect domestic cartels for doing bad things elsewhere. And of course, 1982 FTAA is the best example from this jurisdiction. Then we can have a case of lax and under-enforced competition law regime. So we can have great competition law on the books and very little of its enforcement, or maybe very little of its enforcement in some sectors. And maybe potash production in Canada is a good example. Canada produces potash, it's one of the world-leading producers. Allegedly, it cooperates with other potash producers internationally and sells most of that through a cartel-like structure. And although Canadian domestic market is also affected, most of the potash goes abroad. So overall, Canada probably is doing pretty well. And Frederick Jenny writes about it, and I refer to his paper here. And we can also have a sort of a subtler case of merger review. So we can have a situation when domestically certain mergers are cleared, although overall they're anti-competitive, but perhaps domestically that makes sense to clear them because that merger will strengthen the comparative advantage and the position of the merging firms on the wider international market. And we have cases of that sort, for example, Glencore in Europe, which involved merging South African mining firms. The interesting issue about facilitation is that these sort of acts and policies do not end up in foreign courts. They are never raised and discussed. Why? Because these are economic policies. And economic policies, sovereign choice. The sovereign choice is not actionable under any sort of competition law internationally. And of course, such economic policies, they also don't violate any international competition norms. We don't have many international competition norms. We, for example, have a rather universal, nowadays almost universal, recognition of the harmful nature of private hardcore cartels, but these are always private cartels, never public agreements, agreements between states. So facilitation is itself a very broad and diversified category of acts. the state can go even further, and instead of encouraging and facilitating anti-competitive conduct, it can actually compel it. That's the case of, for instance, compulsion. And of course, that happens quite, maybe not quite often, but we know, we see cases, for example, in US courts involving Chinese export cartels, in which defendants argue that, well, it was not us, it was the Chinese government. And of course, if that's the case, competition law offers no remedy against directly involved firms, and the question is whether we can do anything about it, and probably not. Of course, the problem with compulsion is that we have to be very careful about the standard, because if we set it too low, we're creating incentives for foreign firms to lobby their governments to either introduce issue laws which ex ante order conduct which firms agree themselves between themselves, so that they can benefit from the defense, or maybe issue some sort of statement ex post, as probably has happened in the vitamin C case. Last but not least, we have the case of management of natural resources, and that's actually how I got to think about these issues. These are cases such as OPEC, when governments decide to do something about natural resources they have. The general view holds under international law is that states have perfect, complete sovereignty over their natural resources. That includes also the notion of, whether you actually extract resources, at what pace you do that, whether you grant licenses or not, and those decisions are considered sovereign and are not challengeable under competition law. That doesn't mean that each and every case involving natural resources is shielded from scrutiny in foreign regimes, and I think we should be able to draw distinctions on facts between a situation when a state is implementing a long-lasting policy on extraction exploitation, and whether a state is, for example, granting a state-owned enterprise a license without any plan of extraction exploitation, and that entity later engages in anti-competitive conduct. So, for example, in Europe we have now an interesting case involving Gazprom, which allegedly is abusing dominant position. And I don't know, of course, the facts. I don't know the publicly available information, but it seems there's no economic way in which you can justify why countries far away from Russia paid much less for gas than, for example, Lithuania, which is a neighbor of Russia. And now European Commission is looking into this sort of issues. So these were acts and policies which were outbound and caused competitive harm elsewhere, and that's usually the case. But we can also have inbound-oriented acts and policies which cause competitive harm elsewhere. Here, I would like to single out two categories of acts and policies: embargoes and bias cartels and boycotts. And here we can have bias cartels organized either through establishment of formal ties or through consolidated buying. Is that issue topical and worth our attention nowadays? And I think the answer is yes. There's a growing interest, especially in Asia, in collaborative purchasing, especially when it comes to liquefied natural gas, and the first joint purchases have already taken place. Moreover, in the European Union, we're now talking about creation of energy union, and within that package, Commission is also looking at allowing mechanisms providing for joint negotiations of purchase contract with Russia. A very, very delicate issue and slightly political, but quite interesting nevertheless. When it comes to embargoes, of course, embargoes as sovereign acts are not actionable. The best example is maybe the embargo introduced in this jurisdiction in 1960s on importation of foreign uranium, which led to creation of international uranium cartel under patronage of a number of governments. So that was the mapping exercise. In the paper, I also talk about what's the next step, what can we do about it, and I argue that we have to distinguish, and quite often these cases are difficult, and I think that agencies should be bringing them also so as to signal to all the market participants that are very serious about competition law enforcement, because that may also help them to negotiate certain things intergovernmentally and maybe deal with some of the anti-competitive conduct which is implemented by means of economic policies. And I think I stop here. Thank you very much for your attention.
Thank you. So we'll get the discussion going, first with Professor Kavanaugh.
Thank you. You learn a lot at these conferences. This morning we were talking about, this is the 6th year of this, and we're talking about the next generation scholars and the last generation scholars. So I guess we're all getting older. But then Andy Gavel reminded me that based on my picture in the promotional materials, I was actually looking older. So I didn't feel good about that. I was also happy to learn that there's actually a word called pre-competitive. Now, check this out. Whenever I type on my word processing program, if I ever type the word pro-competitive, and I bet we all do that, it always corrects to pre-competitive. Always. I don't know what that is. I'd be interested if everybody else has that experience. But now I know that there's actually a word called pre-competitive, so I feel better about it. Anyway, Merrick's paper, I was happy to be able to read this piece. I think it makes an important contribution to an emerging area of literature regarding potential antitrust liability of state-owned or sponsored enterprises. This builds on the work of Eleanor Fox and Deborah Healy. Eleanor Fox and Deborah Healy, when State Harms Competition, the Role of Competition Law in 79 Antitrust Law Journal from 2014. The surveys that were conducted by Professors Fox and Healy revealed that the competition laws of all of the respondents covered state-owned enterprises with few exceptions. And furthermore, that the competition laws of those countries were designed to prevent state and local governments from undermining competition laws of national authorities. And I think their study confirms a shift from hostility to antitrust enforcement toward more pro-competitive policies, and demonstrates a growing awareness of potential market harms from state-owned enterprises. We've come a long ways, I think. The international community, we now have some 130 enforcement authorities. 40 years ago, I recall when there were far fewer during the uranium litigation, which in the private phase was Westinghouse against the 30 major uranium producers in the world. In the UK, government was not happy about this action and implored the State Department and the Department of Justice to stop the litigation, and they were informed that it doesn't work that way in the US. So the cases went on, the Westinghouse cases went on, so what happened was that Parliament passed a so-called clawback legislation, which says any UK entity that is held liable for treble damages in the United States can get back that 2/3 punitive portion in a civil action in the UK. And of course, Westinghouse had huge operations in the UK, so they would have been subject to that. Okay. In addition, other nations, notably Canada and Australia, but other ones passed legislation that made it very, very difficult to get discovery of uranium documents for use in the United States. Today, this sort of blatant hostility to antitrust enforcement is the exception, not the rule. Now, Merrick's thesis, of course, Merrick builds on the work of Eleanor and Professor Healy, and Merrick's thesis is that states should not enjoy immunity from enforcement when they inflict competitive harm through their commercial dealings. And so anti-competitive harm that results from commercial dealings should be subject to challenge under competition laws, irrespective of whether the perpetrator is a public, a private, or governmental entity, unless there are overriding reasons to abstain from enforcement. So what Merrick gives us basically is a rule with an exception. The rule is easy. All commercial dealings by state-owned enterprises should be subject to antitrust scrutiny. The exception's hard. Okay? When is it appropriate to forego prosecution of state-owned entities who are engaged in anti-competitive conduct? Now, we've long recognized lots of activities that governments can enter into that are outside the scope of antitrust scrutiny. Minimum wage laws, rent control, zoning, public transportation, natural resource management, military procurements, acquisitions that are related to national defense, full employment public policies, public transportation, postal services. And in a sense, I guess those are kind of low-hanging fruit. But traditionally, we followed, to determine what else falls into that privilege category, we followed a bright line rule, okay? Was the government acting in a sovereign capacity or a proprietary capacity? And as a first cut, that's a good test, but on the other hand, sovereign and propriety are just words. But this test has been, utilized by enforcement agencies. If you look at the Justice Department's International Antitrust Guidelines, Section 331 makes the sovereign propriety dichotomy, or utilizes the sovereign propriety dichotomy. The courts have developed, as we all know, a number of legal doctrines under which governmental entities can avoid scrutiny. Okay. Sovereign immunity, act of state, sovereign compulsion, justiciability in the sense that activities of foreign states are political in nature and therefore outside the competence of courts. The thing is, these doctrines, I think, remain remarkably undeveloped in not only the courts, but also in the antitrust literature. And it seems to me that in applying these doctrines in the U.S., courts have been willing to find immunity by the slightest showing of sovereign interest. And I think OPEC is the best example of this, which is probably the best known cartel ever. And yet, on all four of those theories, courts have said that there's no subject matter jurisdiction here. So the line that delineates sovereign and proprietary capacities is not always bright, and indeed, the concepts of proprietary and sovereign may not even be mutually exclusive. Now, I'm not suggesting that the courts always get this wrong. If you look at the vitamin C litigation, where the Chinese government jumped in a cartel situation to try to protect some of the Chinese participants in the cartel by saying, no, we forced them to do this. I think, that kind of naked post hoc assertion the courts saw through and rejected. But the question of which factual circumstances justify abstaining from prosecution of state-owned entities for their anti-competitive conduct, I think needs to be explored in more depth. And I'm not suggesting you do it here, Merrick, but I think this is your next piece to develop that in more depth. Now, I have three specific comments outside of that kind of general comment. And, one, you cite Pfizer against India for the proposition that foreign governments ought to be subject to antitrust lawsuits. Pfizer against India was the first Supreme Court brief I ever worked on, so I know a little bit about that case. That was an offshoot of the tetracycline case. But the issue in that case was whether or not India, as a foreign government, was a person within the meaning of Section 4 of the Clayton Act. And the defendants argued, no, it wasn't, because the United States, correctly, that the United States was held not to be a person within the meaning of Section 4. And of course, that's what generated eventually Section 4A in 1956, which allowed single damages, and since then, we allowed internal damages for the United States in civil cases. But in any event, we argue that if the United States is a person, then a foreign government, a fiduciary is not a person. The plaintiffs argued and said, no, you've got that all wrong. He said that the reason why the United States wasn't permitted to bring actions for damages is because it had this whole panoply of remedies, injunctive relief, criminal remedies, and that it was just piling on to let them have another civil remedy. And that's really what drove that decision. And secondly, states can sue under the antitrust law, so states are sovereigns, they're sort of like foreign governments. And in any event, what's the logical distinction between a foreign corporation suing and a foreign government suing? Of course, ultimately, the Supreme Court held that India was a person. But I think sometimes there's too much made of that. It's much more narrow. I don't think being able to sue and being subject to sue are the same thing, because you've already recognized that there are reasons why foreign government shouldn't be subject to sue. Okay. The second thing is just you mentioned about the uranium embargo. I worked on the uranium cases. I was really pleased. Two cases.
I feel like there's been some sort of setup.
Yes.
Someone's involved.
Danny could not have possibly known, because all this happened before he was born. But in the uranium case, you cite the embargo on uranium as a causative factor I strongly disagree with that. That might have played some factor, but the real reason why the uranium cartel was formed was to target Westinghouse, which was an intermediary in the marketplace, which was buying up a lot of uranium and reselling it to utilities without having its own source, reselling it to utilities at low prices and keeping the market low. That's why the major international uranium producers got together and said, we got to get rid of it, we got to annihilate Westinghouse, identify Westinghouse as the problem and annihilate it. And one of the best hot documents I've ever seen. So if the embargo was a factor, it was a minor factor. The real factor is what the actual illegal conduct. And the third thing, the FTIA. You mentioned the FTIA. Are you saying that it was designed to protect domestic producers from antitrust liability abroad? If you're saying that, I would disagree. You know, the FTAIA tried to define the limits. You know, the Sherman Act applies to the domestic and foreign commerce in the United States. So it tried to define the limits of foreign commerce. And I don't think it protects United States companies from liability in the international market as much as it prevents foreign plaintiffs in foreign transactions with foreign buyers from having the United States from having a trouble damage platform. But as I say, I enjoyed reading this paper. I think there's another one here, and I look forward to reading that too, and I'm pleased to have had the invitation to do this. Thank you.
Great, thank you. Liesl, can we bring you into the discussion?
Sure, and I'll be quick because I think we don't have a lot of time for all three of these. I found this a fascinating paper, really, really interesting. I don't have the depth of experience that Ned does in actually having worked on briefs for the uranium embargo or those cases, but this is an area that I hadn't given much thought to before, and I felt that the paper did a really great job of providing a framework for considering foreign state conduct and what kind of factors you need to look at to try to delineate whether something is commercial, sovereign, whether it's justiciable, those kind of concepts. And so I found it really helpful in providing me, someone kind of coming to it fresh with a framework for considering those things. One weakness, I noticed the FTAIA thing as well, because you were using that as an example of how states use their laws internally to, protect people who might be doing anti-competitive things. And I agree with Ned that the FTAIA doesn't do that. All it does is prevent suits from being brought in the US. But of course, if a cartel is formed and does something bad in the UK or anywhere else that has competition enforcement, which is most of the world these days, it's not going to protect them from doing that. It's not a compulsion, and so I don't think that's a good example for the kind of thing that you're talking about. The only thing that left me a little unsatisfied with the paper is it's very rich in examples and cases, and I learned so much more about OPEC, because when I picked it up I said, oh great, now I'm going to learn about OPEC, and I did. I learned a lot about OPEC. It was really, really interesting. But you say in a couple of places and in the conclusion as well that there's a gap. And I didn't get the sense of where the gap is. That the examples were given for, this is how this court treated it, this is how that court treated it, but there was no identification of, how something should have been done differently, or where states have failed to act. And the sense that I got from your oral presentation is that your central thesis is that there's a lot of anti-competitive conduct going on by states that perhaps should be more thoroughly investigated, prosecuted, enforced against, and that it's not been. And I missed where that is happening, despite this really rich collection of examples.
Thank you, Liesl. So
I think Merrick is going to have to get a plane, so you can go whenever.
No,
I don't want it to look like after we talked about your paper, you got up and left in a huff.
Duly noted. I'd happily cede my time to someone on the floor if anyone has a question. Otherwise, we'll probably move on to the next paper. So, okay. present her paper entitled Rate Making Through EU Law, Competition Law, and Regulatory Approaches. Niamh is an assistant professor in the London School of Economics. She teaches in competition law. Before arriving at the London School of Economics, actually quite recently, she was a lecturer at King's College in London and a fellow in law at the Fitzwilliam College in Cambridge. She's also worked at competition enforcement for the CMA, the Competition Authority of Ireland, and as well she holds law degrees from the University of Cambridge, NYU School of Law LM, welcome back, and King's College, and she's qualified to practice law in Ireland and New York State. So a New Yorker, in a way, right? Of course. And I'll just quickly introduce Professor Patterson of Fordham Law, because he's going to be the practitioner, the academic discussant here. Fordham Law, he teaches and writes about antitrust law, patent law, internet law and contracts. He received his Master's of Science and Bachelor of Science degrees from Ohio State University in electrical engineering and his JD from Stanford Law School. He's been a visiting professor abroad at the Boccini University in Milan and the University of Navarra in Pamplona, not bad locations, as well as a visiting fellow at the European University Institute. His current research focuses on the antitrust treatment of informational issues, and he is also a registered patent attorney. So, Niamh, would you like to offer your presentation?
Okay, so good afternoon. It's a real pleasure to be here. My paper deals very broadly with the issue of what I'm calling rate making by the EU institutions, so either the European Commission or the European Legislature of the Parliament and the Council. What I really mean here is regulatory price setting. So when the European institutions devise and make binding a price to be charged at either the wholesale or retail level within the member states. My paper starts from the assumption that this is and should be an extraordinary activity. It then looks at certain recent instances of such extraordinary regulation and tries to provide some rationale for these discrete instances. My argument is that you can trace a link in all 8 examples, I think there are in total in the paper, to the digital single market. I take a very broad definition of what the internet economy, or what's sometimes called the new economy, comprises, and try to show how all of the examples that I point to can be linked to this notion of the internet economy. Whether that is a good or bad thing, whether I suppose we can defend this regulation is something that I think I haven't quite determined yet. The paper is in a relatively early stage, so I'd be very interested in having feedback on that point. We've talked a lot about today in earlier sessions the notion of, I suppose, EU exceptionalism, and this is another example of exceptional activity by the EU. I think you don't have to be a public choice scholar to accept nowadays that price regulation is something that is disfavoured, and to understand the reasons for that. Price regulation tends to be quite difficult to do. Done badly, it can be very counterproductive, leading to harm for consumers and harm to competition. Think of examples like the collapse of the Californian energy market, the fact that you basically can't buy fresh milk in Venezuela today. But beyond that, there are reasons why rate-making activity is something that at an EU level is particularly, I suppose, counterintuitive in many ways. First and foremost, the EU as an institution is premised on the idea of clear, open, undistorted, free market competition in support of the internal market. And this is something that you have a textual basis multiple times throughout the treaty for saying. So rate making, price fixing, price regulation, is very much, I suppose, anathema to that broader idea. And both the European Commission and the European courts tend to be very sceptical of rate-making activity when it takes place at a member state level. There was a high-profile case on the 23rd of December last year relating to attempts by the Scottish Parliament to engage in minimum price setting for alcohol. The Court of Justice basically is very, very sceptical as to whether this would be compatible with EU law more generally. You also see this in the activities of the European Legislature, of the European Commission. In terms of antitrust enforcement, the Commission has said it is not and does not want to be a price regulator. You also see this in the approach to most legislation, which is about, I suppose, reinforcing competition in the internal market, not about determining the outcome of the competitive process. The second reason I think that rate making is an exceptional activity relates to the, I suppose, constitutional structure of the EU. And Alan Dashwood has talked about the intermediate position of the European Union compared to the member states. The EU is one step further removed from national markets, from the, I suppose, ordinary populace in the member states, than national governments. And for that reason, I think price regulation becomes more difficult to justify. Issues about the democratic deficit are perhaps overstated by some political scientists, but it is the case that there is this remove. And so it's more difficult, I suppose, in terms of the democratic mandate to justify, to legitimate price regulation. It's also more difficult to do well. The one-size-fits-all solution that you tend to get at EU level may not work so well when it comes to price regulation. And finally, there's a point relating to this very important principle of subsidiarity, which underlies all EU, or most EU, activity, which is the idea that the EU should only step in when it can achieve a particular goal better than the member states acting alone. And that's a difficult argument to make when it comes to price regulation. Often, as I've sort of alluded to, often price regulation is better when done at the closer, more local level. It's also more difficult to argue that price regulation at the EU level is going to be proportionate, another important constitutional principle. So most EU instances of regulation or intervention in the market do not involve anything as prescriptive as price regulation. There is, as was discussed in an earlier presentation, quite a lot of use of sort of FRAND principles, maybe requiring access and requiring non-discriminatory terms for accessing a particular product, but EU law tends not to set an actual price that ought to be charged. The paper then goes on and looks at a number of recent instances where this precisely has happened. I look at 6 cases which have involved antitrust commitment decisions with 5 firms, Rambus, Standard & Poor's, IBM, Thomson Reuters, and Visa, incidentally all North American firms, which starts to hint at another maybe contentious question in terms of current EU competition enforcement, where the settlement in those cases involved a direct price setting remedy. Lots of different case theories, but ultimately the same outcome in these cases. No finding of infringement. The commitment decision procedure is essentially equivalent to the consent decree procedure in the US. And I also look at 2 instances of legislative harmonization, the roaming regulation from 2007 and the very recent interchange fees regulation, setting prices for interchange fees from, I think, last December, where you have a sort of a market-wide remedy being imposed by the European Union, by the legislature. The difference, I think, between the antitrust examples and the more intensive regulatory examples is there's a strong consumer protection dimension in the two regulatory harmonization examples. So what is the explanation for these extraordinary instances of rate making? What I argue, drawing on work that's been done in the OECD relating to the internet economy or the digital economy, is that all, I suppose there's 6 different markets involved across 8 different examples of intervention, is that all 6 can be traced in some ways to the notion of the internet economy. Using a working paper from the OECD from 2014, the OECD pointed to 4 different components of the internet economy relating to infrastructure, connection, services, and content, and I think all of the examples in my paper you can link in some ways to one of these 4 categories. I suppose the reasons why we might need intervention in these particular markets is, well, in these sorts of sectors you tend to have problems of either lock-in or network effects or both. You tend to have a transnational dimension which may make intervention at a domestic level more difficult, so overcoming the subsidiarity point. This is a circumstance where EU-level intervention is going to be easier to justify because it's going to be more effective. And you also have, I suppose, the absence at a member state level of a clear consensus that regulation in digital markets is going to be a good thing. What the cases show is that we have competition problems arising, and what I think the Commission is doing, the European legislature with its interventions, are kind of a more ad hoc sort of 21st century public utilities regulation for these digital markets. whether this is a good strategy or whether it just reflects, I suppose, an ongoing, maybe current policy preoccupation of the European Commission is something that I think is more difficult to determine. I come to sort of the limits of my own competences as we get into the question of how should we regulate the internet economy. So I would be very interested in hearing on that particular point. But yes, that is my favourite.
Thank you, Niamh. Professor Pattison?
Okay, so when I first saw this paper, and even when I read the introduction, I kind of thought it was going to help explain to me excessive pricing cases, exploitative abuse cases in Europe, which we Americans, or at least this particular American, find mysterious. But it doesn't do that. It's not what it is. So I guess my first suggestion might be that you might want to make the title more clear. Like it could say rate-making remedies or something like that, because it's really about price remedies and how they fit in the EU system and in the digital economy. So the first point I think probably everybody agrees with, that price remedies are problematic and that we generally want to aim our work at process, or remedies at process, not at results. But I mean, one thing, I guess my main point, my main comment on the paper is that I think it would benefit from an exploration of alternatives, particularly in the context of the cases you talk about. So it would be helpful, I think, if you're not going to impose a price remedy, then exactly what would you do? Because I take the point that fines are the typical, finding of infringement and a fine is the typical approach. But it's just not clear that that would be really effective in some of these cases. So I'll talk about the cases in a little bit. But first I'm going to talk, the first portion of the paper talks about the EU issues. I think at one point you say we shouldn't be doing this, we're hostile to price regulation at a national level, presumably because we want that, we think all that, figure that will hinder the single market. But then later you're unhappy about price regulation at the EU level too. And so I understand there are different reasons, and maybe it's perfectly fine to be hostile to price regulation at both. But at least at the EU level, I mean, the fact that these are American companies and therefore are probably not engaging in activity that's country specific as opposed to EU-wide suggests to me that maybe an EU-wide approach is not such a bad thing here. And it's not as if the EU is hostile to uniform pricing. I mean, some of the other EU rules, like ones against territorial restraints, tend to encourage arbitrage. And so, is it really true that the EU would be hostile to uniform pricing? Was one question that I came up. And again, maybe so in these cases, but then I would like to hear more about these cases. And so most of the cases you talk about are abuse cases, abuse of dominance. So the Standard & Poor's, the Reuters, the IBM, the Rambus are all, we would call them essential facility cases if we weren't so unhappy about essential facility doctrine in the US. And the credit card cases are just one-on-one price fixing cases. And so in each of these contexts, rate setting doesn't seem that bad to me. I mean, in an essential facility case, the key is if you're going to mandate access, you have to really tackle the price issue because there's no point in saying you have to provide access if really high prices can be set. So I just don't know exactly what you would do in these cases if you weren't going to set price. I mean, even in the US, we're probably more hostile to price setting. The FTC's case against Rambus also set price. I mean, it was reversed later, but not for that reason. But we just don't pursue these cases, or the agencies in the US don't pursue these cases. If they did, and they entered into consent decrees, I can imagine they would also set price, probably. The 101 case is a little harder. I mean, you can condemn a price fixing agreement without setting a price, but in this case, it would be hard. You really probably need to set a price initially, at least, to get them off the price that they had been using in the past. And so what that suggests to me, and you suggest at one point, I think I read you correctly, to say that the agency, the commission, is doing rate setting, but it knows that's bad, and so it tries to sneak it through with commitment decisions or something like that. And it seems to me that maybe not, that these are cases that maybe make sense as commitment decisions. They're really forward-looking cases. So I guess the causation sort of might run the other way. Or maybe not causation. It makes sense to have them as commitment decisions, and then the remedy that makes sense in the commitment arguments probably is price related, or at least if it's not, I would like to hear you tell a little bit about why it's not. What remedy would you recommend if it weren't a price remedy? The regulatory examples that you have also don't seem that surprising to me. I mean, regulation is traditionally about rate setting, and so and those are EU-wide issues, roaming and interchange fees, and so that kind of makes sense to me too. So then in the last section, you pull your examples together and you argue that they're part of the digital economy. I guess they're very different. So Standard & Poor's and Reuters, they're about digitally provided information, but they're really like quasi-IP assertions or something like that. And they all seem sort of peripherally digital, but not centrally digital. Rambus is about computer memory, but it's really about standard setting. It could be any standard setting. IBM is about computers, but it's really a typical third-party maintainer case. And so roaming and interchange fees, legal at least, they're joint venture cases. They use digital technology. So I guess I'm not sure that inherently these cases are digital, but I don't think that makes your point less valid. I think it actually makes it more interesting in that it may well be right that the reason they're being pursued this way is because they're seen as being in a digital market, even if I think what would be more relevant is the economic characteristics of these products. And you talk a little bit about that. You talk about network effects and lock-in. And so again, I guess I would maybe dig down a little bit more into the nature of the products and whether it makes sense to have a price setting here. I also found interesting your comment about these are innovative markets, and therefore I think your statement is rate setting is particularly suspect in the digital economy. I guess I wonder about that too. I mean, the innovation in the digital economy is not about price mostly, right? And so it seems like one could argue that you're going to do less harm to whatever innovation is happening in the digital economy if you maybe mess with the price stuff, but don't mess with the non-price stuff where the innovation is really happening. And so, again, it just suggests again, maybe talk a little bit more about the details of what's going on here. So I think that's all I have. I actually think it's it does a great job of raising interesting questions about price remedies, both on the EU angle and the innovation angle. I just would like to hear a little bit more of you describing what you think should happen in these cases.
Liesl?
I'm requesting. Oh, there we go. Okay. I really enjoyed this paper. I enjoyed all the papers, but it was easy to read and well written. So thank you for that. Certainly made my job a lot easier. I share the concern about the discussion about the excessive pricing concept, and I felt that I wanted more there because I've always found this idea that in Europe the Commission will go after companies solely for excessive pricing, a really odd one. I mean, surely the basic theory, market theory, is that if you're a monopolist, you charge the monopoly price, and the monopoly price is what it is. I'm getting a shaking head here.
If I think about Gazprom. That's
Extortionist versus monopoly price, but monopoly rents are monopoly rents, and we encourage. We want to incentivize people to innovate and develop new ideas and new technologies and new businesses and things like that. And the motive, the concept that's incentivizing them is potentially the ability to gain some monopoly rents for some period of time. Now, obviously, what's happening here, and I think what Niamh draws out, is that once this innovation has taken place and something new is created and becomes very popular, you end up with network effects and lock-in, and suddenly you've got somebody who's continuing to charge monopoly rents in that circumstance, and you get these overriding concerns of consumer protection, and coupled with the excessive pricing is often other acts by the monopolist which are more traditionally anti-competitive. You get bundling behaviours, you get restrictions on competitors from accessing essential technologies and things like that that they may need to develop competing competitive products. Things that I think we would condemn here in the US as well. But, you know, excessive pricing on its own, you know, I find that very hard to kind of conceptualize, and I think I would have liked to have seen a bit more discussion of that, and particularly the economics of it, because you do lay out some of the arguments for why excessive pricing is a realistic theory, but there isn't a lot of economics to explain that. And equally, there isn't much economics explaining, you know, the model of monopoly and monopoly rent. So I think that's something that could really, you know, further the discussion in that area. I liked the drawing together at the end in this, you know, trying to put together a framework or a connecting theory for all of these cases where there has been some kind of rate setting. But I don't know if just, you know, if trying to label it as digital economy was really helpful. You know, because, you know, as you said, you know, they're very, very different markets and very, very different industries. And yeah, sure, they're all new and they all kind of use the internet and new stuff in some way, but that's not what's really making them similar and susceptible to this kind of regulation and treatment. I think the factors that I took away from it and the unifying principles that I found most compelling were that in each case where there is some kind of rate setting, you're seeing more traditional anti-competitive conduct. It's not just, I don't think any of these cases were brought because there had been solely excessive pricing. All of these, the two rate setting examples, came after competition inquiries into the market sectors and antitrust cases against the participants. The undertakings in all of the other cases, like RICS and things like that, although there is a price element of it, it comes along with undertakings about future conduct, you know, that they won't conduct themselves in the anti-competitive way that they were previously. So that to me was a very strong unifying principle. The interchange case is fascinating. I mean, interchange is one of those areas that you know is very divisive globally, you know, and each jurisdiction is dealing with it differently. You have the US, which is still trying to rely on, you know, market principles, government bringing litigation to try to remove some of the you know, ancillary anti-competitive barriers that the credit card companies have put up around anti-steering rules and things like that, but leaving the rates themselves alone, hoping that once you get rid of all of the other anti-competitive and restrictive trimmings, that the market will assert itself and the rates will come down. And then you have Australia, Canada, now Europe, actually trying to set a rate. And I think the jury is really out on how successful which method is going to be. We're kind of in the middle of it. I know that in Australia it hasn't been entirely a success, but they're still going with it. So, but thank you.
So I think in the interest of time, we'll move on, unless there are questions from the floor. We can always capture those at the end as well. I think we'll move on to the next paper, presentation. Professor Avra Bose will present his paper entitled Institutional Design in India's Competition Law. Dr. Bose is an assistant professor of competition law and policy at the Jindal Global Law School, and also serves as an assistant director of the school's Center for International Trade and Economic Laws. He also serves as an antitrust consultant to the government of India's financial think tank, the National Institute of Public Finance and Policy. He worked as an expert consultant to the Competition Commission of India, and he's a graduate of the WB National University of Juridical Sciences, and Harvard Law School, where he specialized in antitrust law. And in fact, this spring he's at UC Davis for the term, teaching a course on comparative antitrust law. And commenting as the academic discussant is Eleanor Fox, who many of you know is the Walter J. Derenberg Professor of Trade Regulation at New York University of Law. She is an expert in antitrust and competition policy and teaches, writes, and advises on competition policy in nations around the world and in international organizations. She received her law degree from New York University School of Law in 1961 and received an honorary doctorate from the University of Paris Dauphine in 2009. So I'll turn it over to you.
That's what when it's read.
Okay.
Thank you, Danny, Harry, Edward, for sort of giving me this opportunity, and Liz and Elizabeth for your comments. And Liz will still comment. I mean, thank you from beforehand.
That's a good, very good tactic. Just kind of lay the ground, right?
He brought us cookies too.
Yes. Oh, that's all you got, Liesl? I have a goodie bag.
And I'm also very, I'm aware that, I'm the only person who is standing between you and the cocktail hour or the impending storm, which one is a priority. So I'm very happy that you guys are still here. And I'm very proud that, that I never thought this would happen, that I and Eleanor would be mentioned in the same paragraph. Growing up, reading her work, I mean, it's an unbelievable honor. So, my paper is Poverty of Antitrust Reasoning, 5 Tales from India. I spent 4 years of my life practicing antitrust law at Weill Gotshal in New York. And there, then directly went, I don't know why I did it, I got an offer from the government of India to be an advisor to the Competition Commission of India and help it set up its procedures for 3 years of my life. So this paper is my frustration, documented in that transition. To give you a little bit of a context, India has not received as much as scholarship attention as, for example, China has, and that's might be because of its own fault. It's a big market. It's not as big as China, but it is obviously a very important market, especially from foreign, from international point of view. If you ask, people who represent Google or Ericsson or Facebook, all of these have major exposure in India, and all of them have some antitrust concerns going on there. What makes India even more unique is it's perhaps one of the few jurisdictions which doesn't allow you to settle. So therefore, in a way, how the agency behaves, how the court system behaves becomes an important factor to consider in terms of antitrust risk hedging. And in some way, this paper is a continuation of the discussion from a few of the panels in the morning as to how various jurisdictions end up deciding antitrust disputes, like what goes on behind the minds of the enforcer or the judges. Angela Zhang did a work on bureaucratic politics of China, which was an explanation of the Chinese agencies. In some ways, this does so for India. Now, there have always of Indian competition law for a very long time have complained that, in spite of being in existence for 6 years, in spite of actually having a law which is directly modeled after European Union, it doesn't reveal, actual decision doesn't reveal a lot of robust economic understanding or doesn't reflect an intellectual rigor. Last December, the Economic Times of India, which is India's largest circulated financial newspaper, brought about an industry piece which sort of chronicles this problem, and where members of Indian antitrust bar, again, it's a closed legal system, so you do not have any representatives but Indians but they have commented, they've been very critical of the Competition Commission of India's work over the past 6 years. One former chairman and two former members and a sitting member has in that paper also been critical. So it's something that is not new, that India is not really pulling up its socks and behaving like a jurisdiction it should behave given the market. So my paper tries to investigate why doesn't India do so, like what stops it from really looking at these antitrust cases, which is sort of happened in the other jurisdiction, and try to learn from those when they're deciding those similar issues in India. And that's the paper. So, part 1, I give some of the reasonings in my paper. Part 2, I discuss actually 5 cases, which are these 5 tales, where, this sort of problem manifests itself. Drawing upon Lance Pritchard's work called Capability Traps in 2010, he wrote he teaches in the Harvard Kennedy School. They talk about concepts of isomorphic mimicry, which is basically a theory of where developing countries imitate the institutional forms from developed countries without building capabilities in that particular jurisdiction, which results in having a legitimacy in the international community because from the distance, the institutions look similar. You know, the law looks similar, but in reality, when you actually go ahead and practice it, that's where, you know, the devil lies in the detail, and that's where the problem begins. Having this in mind, you know, the Indian antitrust law is a product of its, you know, its new liberal experiment, of its liberalization process, which has reached 25 years this year. It was an act which was created to remove bureaucratic discretion from how, you know, private firms behave, and to replace it with modern principles of antitrust. Now, in my paper, I've tried to demonstrate how, in spite of those, you know, in spite of having a modern, quote-unquote, modern antitrust law, how the bureaucratic discretion hasn't gone away, how these modern principles have been used innovatively by the agency to replicate a pre-liberalized era of state intervention in markets. And, you know, in that sense, it is, you know, there was this classic joke that in antitrust law, agencies don't like high price, they don't like low price, and they don't want price to be the same, you know. In some way, India has achieved that. The same concept of unfair price has been used to critique when the prices are too high and when the price is too low. It's the same logic, but that's how I try to demonstrate how the, you know, the CCI has gone about doing that. Now, one of the things which has helped the Competition Commission of India, you know, CCI in that, is that the modern antitrust statute was sort of imposed upon almost 40 years of a socialist antitrust regime, which was termed as the Monopolies Restrictive Trade Practices Act, which was introduced in 1969 by then the socialist government, and it had a very similar aim as that of the Sherman Act, because it tried to stop the concentration of economic power in the hands of few people. But the way it went about doing it was through a licensing regime. So, you know, people which had more firms which was quote-unquote denoted as MRTP companies, they had to come to the government and get a license to do almost any aspect of, you know, expansion of business, or even appointing their directors across boards. Many of those principles of that MRTP Act, things like monopolistic trade practices, things like unfair trade practices, I will not go into the detail because of the lack of time. For example, monopolistic trade practices was a mechanism by which maintenance of price at an unreasonable level was considered per se prejudicial to public interest. Now here, two terms, unreasonable was not explained, public interest was not explained. It's very similar to what the EU tried to do with market definition in the 1960s. You know, they tried to impose whatever they thought was, you know, comparable with bananas and apples, and they then made up case law as they went ahead. So that sort of case law exists in India, where what is unreasonable, what is unfair was a very judge-made law, a very agency-driven law, and obviously had socialist parameters. Now, what has happened is, and I'm just using one example because I don't have time to do all of them, is that imagine a scenario where you have a lot of case law that says that the maintenance of price at a very high level is problematic from public interest. You know, and if you see the modern jurisprudence of CCI, wherever it sees high price, you know, because it suffers from, and many of these bureaucrats who now sit on this agency, they were junior bureaucrats during these years when this particular regime was in existence. So they have this logic that high price is prejudicial to consumer choice and sort of manages an economic analysis somewhere in between to justify that end. They do similar things for some other provisions which I've tried to discuss. But now, why does the bureaucrats do it? I mean, it's not that they are completely unaware of the fact that this is a problematic, there's a new law which was introduced from the point of view of remedying exactly what they're trying to do. You know, it's funny because, you know, there's this, I hope I pronounce it correctly, it's a French term called dirigisme, which is basically a form of you know, direct intervention from the state in terms of maintaining economic order. Now, you know, India has asked to move away from a bureaucratic management of the economy, but has actually empowered the bureaucrats to do it. So, in a sense, what they do is that they love, you know, modifying contracts. They try to say to people, oh, this is too high a price, just go ahead and change it. And they find these grand innovative principles in the MRTP to give them a legal jurisprudential logic in doing so. It's like, bureaucratic rent seeking through sophisticated use of legal parlance. And that, again, I'm obviously paraphrasing a much more elaborate project, but in some way, that's what the bureaucrats do. Why is it problematic? Because this is, in a way, prohibiting, in a larger grand scheme of things, it is in a way prohibiting India to achieve sort of a governance framework where centrality of markets is the focus, the entire purpose of having a modern antitrust regime. In a sense, it is stopping India to develop a notion of a rule of law which is based upon efficient market behavior. India has inherited a fused system of courts, where courts of equity also and the courts of common law are the same. Courts of equity are obviously granted with the power of sort of reducing the harsh implications of statute law. So, it literally comes as a package where you have this antitrust regime which goes ahead and gives a very efficiency-oriented outcome, which is sort of then countered through a notion of fairness, which is clumsy and ad hoc. I know I'm sort of running out of time, so I'll just quickly give you one example to sort of give an illustration and then stop. There was, the largest real estate developer of Asia is an Indian company called DLF. It has got a huge land banks and real estate assets. There was a litigation that came about, an abuse of dominance litigation, where the consumer welfare associations of two of their luxury projects, they complained that the apartment buyer agreement between those apartment buyers and DLF was a one-sided agreement. Typically, it was a standard form of agreement where basically they said, if you default in payment, you pay a higher than market rate. If I default in giving you the completed apartment at a particular point of time, I pay you almost nothing. So it was obviously a very unfair agreement. CCI got this opportunity. It looked at the unfair terms, and to be honest, terms were unfair. And it condemned DLF and imposed penalties. Nowhere the CCI even attempts to discuss how this unfairness actually affects competition in the market. It could be unfair, it could be unethical, but it is not the purview of competition law to correct that. Now this goes back to, again, this MRTP regime, just to give an example, because MRTP regime had this notion of unfair, and I think even China in the later 1980s has this logic where there was a form of consumer law which was within the purview of the former antitrust legislations, where where unfair practices on consumer was considered to be an unfair trade practice. This is obviously in the 70s or the 80s. Now India has a functioning consumer protection law, but litigants prefer to use the antitrust jurisdiction because A, it has got the capacity to get huge amount of penalties. And B, in India, antitrust regime is, basically it is an investigatory, the CCI has its own investigation agencies. If you go to a consumer forum, you will have to litigate up to the Supreme Court. If you go to an antitrust jurisdiction, you file a complaint, the agency takes up the buck of actually investigating, and you have the same outcome. So, there are other stories which I've tried to sort of mention in the paper. Hopefully we'll have fun reading them and give me some suggestions. I've just actually been able to describe what the pickle is and how we have got into it. I've not tried to come up with a solution how to get out of it for the simple reason, A, I might not be knowing the answer, and working 3 years with bureaucrats tells me that, they don't like my answer. There's no point actually giving me. Thank you so much.
Thank you very much, and this is a pleasure and an honor for me to have the chance to read and comment upon your paper and your presentation. I'll be right. First I want to say, I really think your presentation was wonderful, and I might even at the end suggest that your paper take on more of the order of your presentation, that this will come. I wanted to say a few words that will actually reflect on things in your paper that you might not have said. So what I want to do is, first of all, commend you. I think you have put your finger on a very important and maybe mind-boggling phenomenon. And you yourself have made the analogy to China. China looks like it's way out there on the continuum of antitrust learning, trying for, let's say, 95% of the time, when it's not doing its own industrial policy, to apply international standards in a way that's very much on the same page as most of the countries in the world. And then there's the 5%, but I'm not going to mention the 5%. But it's way out there, and it's made a name for itself. And then there's India, wonderful, deep, rich, culturally rich India that looked like it was neck to neck with China in 2008 when they were both getting their enforcement on board. And India is just a slow step, maybe a slow step forward, but maybe a step backwards. And China is one of the jurisdictions with which we have to contend. I also think that you put your finger on something very important, on bureaucracy and the past bureaucracy. You've mentioned, of course, prominently the MRTP, the old Unfair Trade Practices Act, which is still the law. But the new competition law was meant to shift to modern competition thinking rather than to carry over MRTP law. And MRTP very much in the tradition of the unfairness that you presented, and also not just that tradition of sort of on the paper and in the cases, but the bureaucrats being appointed in the new regime to be supposedly leading the agency forward. And they are not the bulldogs in the China shop, but they are the old bureaucrats from the old regime. So here now, I want to shift and give 4 challenges, okay? Now, my first one, unless you read the paper, I'm talking to you out there, unless you read the paper, you wouldn't relate to this because Admiral didn't say it in his comments. The paper has a big stress on neoliberalism. And the idea that you propose is that India really wanted to adopt neoliberalism. And look what has happened, it's only perpetuating bureaucracy. So my question is, why do you promote neoliberalism when you could have substituted it in virtually every place for market-friendly? And neoliberalism has an ideological cast, and neoliberalism not only has an ideological cast, but a very generalized ideological cast, where you even say in your paper that maybe India needs something more roots up and contextual, and I find that might be intention. So why the stress on neoliberalism, and is that really another paper you want to write? Because market-friendly will do it every time. All right, number 2, fairness. You've talked a lot about fairness, and your paper is a lot. Well, let me do my 2 and 3 together, because number 3 is cherry picking, but it's really lemon picking. Picking the worst cases to show you how bad the Indian law is. So I want to do these 2 together. I wonder if there's possibly a lack of proportionality or context. I was wondering, doesn't India have some good case law? Doesn't it sometimes have modern thinking? How significant are these cases that you picked out that are the mushy fairness cases in the jurisprudence as a whole? And the second part of that comment is to say, you might have even made some distinctions on fairness. Because sometimes, one of your examples, which you didn't just mention, is an example of a dominant firm that bundles but charges a 0 price on a product that the competitor could otherwise supply. And then another example is the absurd case of the real estate, luxury real estate case, where there are unfair terms to the buyer, but why is India caring about this and it has no market effect? I would say in that real estate case, you're really putting your finger on an error in analysis with possibly incompetent thinkers. And in the other case of this 0 pricing, There's actually an antitrust story that's a market story. If barriers are very high and entry is very difficult. And for a neo-liberal interpretation, you might still want to say we don't want to touch low and even zero pricing because we really want to promote low pricing. However we get to it, as a post-Chicago person, you might be more worried about the exclusionary effect. So I think you might draw a distinction in your paper between those examples that are fairness that has no rudder and is probably based on, I mean, to put a hard term on it, incompetence, and you might not want to say that, but there are other ways of saying this is error. And another saying, it's not error, but there's no theorizing. It's not contextualized. Okay, now my last point is, so that was part of the proportionality too, because I think, put these in context, let us know if there's any good law out there. There's been actually a lot of Indian CCI bashing, and maybe there's a good side of it too. All right, so my last point actually has some in it for that point. My last point is very different. It is a critique, which we're supposed to do right now, is where do you see your comparative advantage in this paper, and how to make the paper better, but also your scholarly trajectory more anchored? And why did you write this particular paper? Is it because of insights that you have, which you certainly do have, about what has gone wrong in India, and that would be enough? Is it because you want your piece to have a larger place in the scholarship, which I'll come back to? Is it possible also that you really want to help the CCI, that you want them to read it, that you don't want to be bashing, but you want to sort of give them enough rope so that they could say, yes, maybe this was an error, and yes, on the other hand, we actually do like some fairness concepts that are actually pro-market concepts, and we want to know how to bring those two together. And another is, do you want to help us lawyers and academics understand India and its competition law better, in which case you probably do more context and sort of deep context. And the final is, which goes together with scholarship, do you want to do a paper that's going to be important in the realm of international scholarship, where the India example is not a single example, that it applies to a number of developing countries trying to get their roots and their grips in trying to modernize and yet not trample on their own values. So I can see a possibility of your using this paper, although it's probably a different or next paper, in developing what is fairness, because many developing countries are concerned about fairness. So what is the concept of fairness that actually can coincide with pro-market solutions? I think developing countries really need that. And this piece, or your one that follows, could be a piece of a picture where others doing research on other countries and how they're using and misusing, or even helpfully using the fairness concept. You can have a kind of, the world might end up with a set of scholarship that they put together that's helpful in our international regime. Thank you.
Thank you for the comments and also for dealing with the chronically drooping microphone. So I'll turn it over to Lisa.
Wow, what can I say after that? And I'm also conscious I'm standing between you and drinks. So I'll be very quick. But first of all, just to everybody, it's been a tremendous privilege to read all of these papers. There is so much scholarship in here, and so much thought, research, analysis. It has been a really great experience. I don't think I've read so many papers in, I don't know, since law school. But this is, wow. This is a real attack. I kind of got to the end of it, and I was going, wow, is it really that bad? And then part of it quotes this article that people publish published saying the CCI has to pull up its socks, and then I started thinking, wow, poor CCI, you know, like, it can't be all that bad. So it's a little bit of Eleanor's comment that, you know, is bashing them over the head going to achieve anything? Like, what is this going to do? Certainly pointing out errors in their reasoning, you know, of just complete lack of economic reasoning, you know, is something that needs to be done, and things pointed out to them. And we did this with China as well. You know, when China would come out with decisions that, you know, mandated continuing contracts or things like that, that, you know, at the time people were saying, how does that actually restore competition? It seems to just, you know, perpetuate an anti-competitive situation. So, you know, certainly it goes on all the time, but I think that, you know, it just kind of ended up with, you know, you're doing it all wrong. And I liked it because it had a definite point of view. But you know, I kind of came to the end of it and I thought, so what next? I found the first part of the paper, you know, interesting, a little dense, but very interesting. The examples were fascinating, and reading these examples of how the CCI had actually approached particular cases was very interesting. I was left on a couple of them though, wondering, well, you know, even if we applied Section 2 to some of this conduct, you know, wouldn't we come to the same result? And this goes to Eleanor's comment about the process versus, you know, where they actually came out. That, you know, they seem to have reached the right result, you know, based on the limited information we've got here, and maybe even said a few things that kind of, you know, made it sound like they were doing a proper antitrust analysis. But then they blew it by throwing in something at the end about, you know, social welfare and consumer protection and fairness. And so, you know, I wondered whether there might be a bit more of an acknowledgement of, you know, the result actually seems to be potentially sound on you know, regular antitrust market principles, but, you know, is it the right thing to be considering these other factors, and should they really be persuasive in the decision making? So that was kind of where I came out of.
Eleanor, I'd like to go back to you for a second, just because you made a comment about the presentation and how that sort of influenced you watching the presentation, and how that might feed back into the scholarship. So maybe if you could follow up on that.
Right. So I thought your presentation focused on the carrying over of the bureaucracy of the old regime. And I think that's very critical in thinking about India going forward. And I also wonder, like you've expressed a wonder as to why India isn't learning and hearing this criticism that it's too bureaucratic, it's appointing the wrong people. On the institutional side, I was really wondering, and your even title is institutional design, I wasn't even sure that the institutional design was wrong so much as the bureaucrats are appointed. And these are bureaucrats who don't know competition, and they're not quick learners. Oh, well, thank you.
That microphone does not like you. Don't
Oh,
worry,
it
Heather,
doesn't.
you just
I'm
have to
sorry.
move over.
All right. So if only a different, more aggressive, knowledgeable person who is in touch with modern ideas and that antitrust economics were the head of the CCI, both the head of the commission and the head of the enforcement, I think you would get an entirely different result. And how to do that or convince India that it should do it is a big challenge.
Great, thank you. Well,
Yeah, I was going to recommend, because I think I can't wait to read the paper now that we have the password, but I was going to recommend that you reach out to Raghuram Rajan, who's the head of their central bank, had it at the University of Chicago, knows these issues deeply, has looked at these issues deeply with China and then India, and he may be a really great resource or his staff for you to think about trying to implement some of Professor Fox's concepts, because clearly you have something major to offer and they need to hear you.
will say thank you to everybody. There's no shortage of things to talk about, but it's taken a tremendous amount of work and discipline for everybody here to keep their comments such that we don't have to dip into the cocktail hour. So I will extend my thanks on behalf of myself and I think everybody here for really an excellent presentation and an excellent discussion offered both by the academic and practitioner discussing.